the mayor council form of government, council members sued the mayor for failing to nominate and appoint directors pursuant to statute. And the Supreme Court found that when it comes to the council members conceded that they must proceed under any private person who is interested in the portion of the statute regarding the writ of mandamus. And Mayor Lumumba is also proceeding under that statute. And Part 2 of the test required that one seeking a mandamus be authorized to bring a suit. And it said that a private person may only be authorized to petition for a writ of mandamus if he can show an interest separate from or in excess of that of the general public. And the crux of the Supreme Court's analysis at that time was whether the council members had a separate interest or one in excess of the general public. And the council members offered that their interest in pursuing the writ is unique from that of the public at large because of the role they play within the separations of powers. And the mayor asserted in that case, because he did not want to reappoint directors, that one cannot be a public official. He claimed that a duty arising out of one's elected position confers standing for a writ of mandamus. However, because the council members demonstrated by virtue of their position as the legislative check and balance on the executive power of the mayor, the Supreme Court found that a separate interest or an interest in excess of the general public existed for them, and that they demonstrated that they had the standing necessary to seek a writ of mandamus. Similarly, the mayor, the executive power of the state, Your Honor, has a duty pursuant to statute 21.815. He has the duty to superintend and control of all the officers and affairs of the municipality and shall take care that the laws and ordinances are executed. So, Your Honor, the statute confers on Mayor Lumumba the requirement to be set apart from the general public and to seek assistance to make sure that the laws and ordinances of the state of Mississippi are executed correctly by the legislative body of the municipality, which is the city council. So pursuant to statute and decree v. Carroll, Mayor Lumumba does have position and standing to bring his petition for writ of mandamus before this court.
Thank you, Ms. Ayers. Any rebuttal? You may proceed. You still have your face covering up.
Thank you.
You're welcome.
This decree decision is completely inconsistent with Sigler, and I think it should just be distinguished on its facts. I have not thoroughly analyzed it, looking at it, decided it, but I believe that the council asserted, or a member of the city council asserted in that case that he or she was acting in a private interest, and the court went along with it and allowed the mandamus action to proceed. I would say that here the mayor is here in his official capacity only. I think the court should be weighed by his pleadings and act accordingly. And I think Sigler was controlling authority, and for whatever reason, the decree court did not analyze Sigler, even though the Aldridge case was cited, which has the four-part test for determining a mandamus action, and that four-part test was that Aldridge cited, or a quote was actually a quote from Sigler, and so I think that Sigler has been, not only is it still good law, it was adopted by the Supreme Court 3 or 4 years later in Bean, and I think the court, for on its own, reading the statute and should dismiss the petition because the mayor is here only in his official capacity and not as a private person.
Thank you. Before this court, issued any orders or setting or directed any requirements in this matter, and even scheduled it. Want to confirm whether or not this court had jurisdiction to proceed on a writ of mandamus in the manner brought by the mayor against the city council. The court had already reviewed Dupree versus Carroll as guidance on how to proceed with this writ, and in it, it establishes first that we do have a mayor-council form of government, wherein the mayor is the executive branch and the city council is the legislative branch. Each of them has specified duties that are statutorily authorized to perform. Similarly, in Dupree versus Carroll, the city council wanted the mayor to perform one of his statutory duties, which is to bring all appointed executive officers before the city council for ratification and approval upon his reelection, the mayor refusing to do so. As such, the city council, in its capacity as the persons who have to ratify and approve all appointments, sought a writ of mandamus as an extraordinary relief. The court in that case examined first whether or not the city council had standing, and they found that because of their statutory interest and their governing authority, they had standing as another individual with a specific interest, that there was no other means of for them to obtain the extraordinary relief they had other than by writ of mandamus, and therefore the court found that the circuit court did have jurisdiction and authority to issue a writ of mandamus, but it is peculiar in that it has to be a writ of mandamus in regard to an issue that is statutorily impaired. So the court, in reviewing the pleadings that brought before me, identified first that the mayor was asking this in his executive authority to have the city council perform a duty that is required in its legislative authority, and that is to ratify the minutes within 30 days of any meeting. If I said that wrong, please excuse me, because I don't have any notes. Additionally, that action is a statutory action. He has no other means in which to compel the other branch to perform its duty other than by writ of mandamus, similar to the manner required in Dupree versus Carroll. On yesterday, the court did inquire from the parties to find out where we were as far as whether or not the city council had prepared and approved any of the minutes. And also, the court needed some information from the plaintiff to determine what minutes they were actually seeking. That was not set out in the complaint. It was very broad and overridden on that issue, and the court did receive that information so that the record could be clear as to which minutes were in need. The court has been advised and did review the minutes from the preceding day, March 29th, that indicated that the city council did authorize and approve a variety of minutes, is my understanding, and that there are still some outstanding. Is that correct?
Yes, Your Honor, that is correct.
Okay. So the process, as far as the court is concerned, has begun that for the city council members to go ahead and ratify those other outstanding minutes. What I need first is a record to be made of the minutes that are outstanding. Once that record is made, I will listen to any arguments from any counsel if you have any other that you want the court to consider, and a time frame for resolution of this matter, and any alternatives for failure to perform may be submitted to the court for guidance. All right, so Ms. Perkins, this is your motion. You may proceed.
Good morning, Your Honor. Melissa Perkins for Mayor Lumumba, along with Ms. Ayers. I think that the clerk's order is the court.
Is the microphone on?
I think so.
Okay.
I'm not talking into it.
Thank you.
All right. The court wanted a status of the minutes made a part of the record. Is that correct?
Yes.
What we did, Your Honor, we made a chart. If I may.
You may.
And this is the same information that we provided in the form of a letter yesterday, and I'd like to have this attached to the record.
All right. I'll ask the court reporter to mark that as an exhibit to this motion hearing.
Yes, Your Honor.
All right, counsel, you may proceed.
Okay, I want to specify, though, from September 27th, 2021 through November 9th, 2021, These minutes were given to the mayor on this past Friday, March the 25th, 2021. Okay?
Your Honor,
2022, excuse me.
I didn't understand what she said. I wonder if you could ask her to repeat so I can make a note of this.
All right, if you'll just repeat the minutes that you're indicating were provided on March 25th, 2022, Ms. Perkins.
Let me just start at the beginning so we just can take it up here.
And if I can get you to move just a little closer to the microphone.
That better?
That's perfect.
All right.
Thank you.
What we have attached to the record, Your Honor, and in support of our petition for writ of mandamus, we have the date of the meetings and the type of meetings, and we have the minutes approved, and if yes, by whom and what date, and whether the minutes are recorded in the minute book. And this chart starts September the 2nd, 2021, and it goes through March the 29th, 2022, okay? And some minutes have been transcribed and they're in process, I'm assuming. However, that transcription and that process did not start until we filed this petition for writ of mandamus. Now, to answer Mr. Bailey's question that he didn't understand, from September the 22nd, 2021 through November the 9th, 2021, those particular minutes were delivered to Mayor Lumumba this past Friday, March the 25th, 2022. So I just wanted to make that clear. Now, beginning...
Your Honor, no, she paused for a second so I can make this notation and it'll go a lot faster.
Okay, just a moment, because I do know they need to make sure that, in compliance, that they have an accurate.
So September 27th, that's the first day the mayor's got some in his possession?
On March the 25th, this past Friday, 2022, the minutes from September the 22nd, 2021, through November the 9th, 2021, were delivered to the mayor. On September the 27th, 2021.
September 27th, not September 27th.
September the 27th, 2021, through November the 9th, 2021. Those minutes from last year were given to the mayor this past Friday, March the 25th, 2022. Okay? May I proceed, Your Honor?
You may.
Okay. The minutes from November 23rd, 2021 to date have not been presented to Mayor Lumumba. And I think that the court has already indicated that the court is aware of the statutory time period within which the minutes shall be prepared, and that just has not happened, Your Honor. And we would ask the court to enter the relief that we've requested in our petition for writ of mandamus, because the mayor is unable to, first of all, the city council can only speak through its minutes. And the mayor cannot perform his duties unless and until he is presented with the official minutes from the city council. And there has been a severe delay, and we would like this court to intervene and issue this extraordinary relief that we know that's extraordinary, but it's unusual and extraordinary when you have city government who has not followed the statutory requirements as they relate to the minutes. So we would ask this court to grant us the relief that we requested.
Quick question.
Yes.
So am I to understand then that the minutes from September 27th through November 9th are to be excluded in your request for relief?
Yes, that's correct. That's correct.
All right, what says the defense?
Adultery, Your Honor. Your Honor, I have Shanika Mosley, Jordan with me to help me understand what minutes are in the process. But I think we can perhaps stipulate some matters, and it's our understanding that that the January 2022 minutes, which would be January 4th, 11th, 18, and 25, were received from city legal on March 28th. And that's the city legal department has reviewed them, and I believe would have sent them back to the clerk of council, and that the clerk of council is still awaiting approval for the February 2022, the zoning meetings that were in February 2022, March 2022, November 2021, and December 2021. And those are, there should be a denotation of it's a zoning meeting, you know, for those meetings on those days and those months. And that's, let me confer with her if there's anything to add what I just said.
That's not a problem.
We'll make it go quick, right? I don't think I have anything to add.
Okay.
So but I would just argue that there's a concerted action to get these minutes in order. I mean, there was a big batch of them adopted Tuesday. There is a process that includes the executive branch. It includes the legal department. It includes, in addition to a clerk of council, which is Ms. Mosley, there is a city clerk who records the minutes and has a role in reviewing the minutes, and then the mayor has a role too.
Order. I'm hearing a lot of mumbling in the background. It's distracting to the court.
Yeah,
and
so I think the court could hear, you know, what it's heard from council and what it's seen happen to indicate that everybody's acting in good faith. And the court ought to consider staying the matter so that we can continue to get the result that I think will occur in a very timely manner. And I don't know if there's anything urgent and necessitous. The mayor's petition talks about his being embroiled in a garbage contract, but the votes pertaining to that, to my understanding, occurred in February and March. And those minutes were approved Tuesday. So since the mayor is seeking extraordinary writ, there may not be the urgency and necessity for the court to issue such an order at this time, which has, great implications because, we are, a city government. There are two political bodies trying to operate with each other, and then one political officer runs to this court asking the judiciary to get involved in the internal administration of city government. And so, if it were the matter of dereliction presently, where you don't have a clerk of council, you don't have a legal department, you don't have a mayor, and that the city government is in some kind of chaos, I could understand the need for an order, saying, get this straight. but I believe there's nothing curative that will occur by, the court issuing a writ of mandamus today.
The information that the court was seeking from defense counsel also would involve a timeline of information. I do understand that, first of all, these minutes have to always be approved in a regular meeting of the city council. I don't have a schedule of when the city council will be convening. I don't have a schedule. I do understand that there is a process, even though these are recorded, and then they are reviewed, and then legal counsel reviews them to make sure that there are no errors before they are sent to the clerk of the court, who does her role in it, and then they are put on the docket of the city council to be heard. And not knowing that information, in a sense, delays what the court have to do as far as consideration. At this point, the court, not erring one way or the other in regard to the political issues of it, only understands that right now we do have some that are still outstanding. I have a writ before me. I have not heard plaintiff's counsel concede that issue at this moment, and so the court still has to proceed in the manner to require the relief sought. Ms. Perkins, is there any rebuttal on behalf of the mayor?
Yes, Your Honor. I want to make it clear, but for this action, the council would not have started to prepare these minutes. And Mr. Baker says that, and we have it in our chart, that the minutes that were approved on March the 29th, a couple of days ago by the city council, those minutes were never presented to the mayor, and they were never sent to legal. So, Your Honor, we want to make it clear, that we need a ruling from this court. That we need the minutes as requested in our petition. Okay, they sent some to legal, and they're trying to say that there's good faith on both parts, and it's a concerted, effort by both sides. Well, that's not necessarily the case. We had to file this extraordinary relief from this court in order to get something that should be a basic function of city government. And they cannot and will not dispute the information that we have contained in this chart, and that the representations that we made to the court, that they have not followed the statutory requirements and prepared the minutes in accordance with what they should have. And for those reasons, Your Honor, we're asking for the relief that we have sought in our.
And just so that the court is clear, yes, you have on your chart the minutes from the March 29th meeting, but those are still not due at this time. They have 30 days from the date of that meeting to approve those. Is that correct?
They have. That is correct. Yes. Yes. But I did want it to appear that, that the process was complete for those minutes. Yes. That is correct. Court is correct.
Right.
Yes, Mr. Baker.
I try not to get too far into the weeds, but there's also been some change going on about how minutes are approved. Heretofore, that the city ordinance said that the mayor would sign and approve the minutes, and then an ordinance was adopted that took effect in early February, saying that now it was a function of the city council. And so a great deal of those minutes involved the situation where the mayor was directly involved in signing off on the minutes.
Okay.
Yeah, they have. Yeah.
Well, after conferring with the Mr. Begley, after having conferred with your associates from the city government, what is your most reasonable expectation as to when all of these can be completed?
May I confer with one of my associates?
You may.
attorney, if everybody does what they're supposed to do, and I believe legal will be reviewing minutes, including the ones that were adopted, this can all be done Monday. This also includes the clerk of council providing those minutes to the mayor for his signature. So I think that's the timeline. A Monday timeline, everybody does what they can and should do. And
So does the city council meet next week for them to be able to adopt those minutes, or?
I think they meet April 12th.
I was making no special meeting.
No, you cannot adopt minutes in a special meeting under Robert's rules.
And let me add some corollary that they did adopt that batch of minutes Tuesday. That they just, those minutes have not, as I'm told, have not been reviewed by legal before they get put into the minute books.
Okay.
And but the process is moving. But I'm told that that everything can get presented to the mayor that he needs for his signature by Monday. And so I would ask the court to stay its consideration of entry of a writ until next Monday, at 5 o'clock.
The court will take that under advisement. That would be April the 5th, 4th. Should know that. Any response from the plaintiff in regard to that request?
Yes, Your Honor, we object to it. If they are representing that they can do it, then I think that we would need a court order, the written order for it.
Well, there's two parts to it. The court, even in granting the writ, still has to give them a period for enforcement that is still in compliance with the statute for them to do it. So the court is going to grant the relief. However, in granting the relief, I do have to give them a time frame for compliance and also a time frame for failure not to comply to appear back before this court. So I'm trying to just confirm with plaintiff's counsel whether that timeline is suitable for your relief.
We have no objection.
All right, thank you. All right, the court, before the court this morning is a petition for writ of mandamus filed by Mayor Chokwe Antoine Lumumba in his official capacity of mayor of the city of Jackson versus the city council. In this petition, the court has already made a finding that the mayor does have standing to pursue this relief. The court has jurisdiction to hear this matter, and that a request for writ of mandamus is proper before this court, as it seeks the relief of having the city council to perform one of its statutory duties that it has failed to execute. The court, having reviewed the petitions and heard the arguments of counsel and reviewed the exhibits in regard to the minutes that have still not been approved, finds that the mayor's request for relief should be granted. The court will issue a writ of mandamus directing that the city council will order and approve the minutes that have to date not been approved. And those are the minutes from September 27th, 2021, September 28th, 2021, September 29th. No, these were delivered. I'm sorry. Correction to the record. Those minutes have been produced and will be excluded from the request for relief. The remaining outstanding minutes that have not been produced are from the year 2021, the November 23rd special council meeting, the December 7th regular council meeting, the December 14th special council meeting, the December 20th zoning council meeting, and the December 21st, 2021 special council meeting. For the year 2022, the minutes from the meeting of January the 4th, January the 11th, January 18th, January 25th, February the 1st, and February the 4th have not, as of this point, been produced for review and approval by the city council, nor have they been signed off by the mayor. The court has been made aware that the minutes from February 10th, February 15th, February 24th, February 28th, March 1st, March 4th, March 8th, March 10th, March 21st, March 21st special council meeting, March 22nd special council meeting, and March 24th special council meeting have all been presented and approved by the city council at their last regular meeting on March 29, 2022, and awaiting execution by the mayor. The minutes from the March 29th, 2022 regular council meeting are not included in this court's order, as those succeed the filing of this petition. The city council is ordered therefore to prepare the minutes and to have them authorized in the manner required pursuant to law and presented to the mayor by no later than April the 4th, 2022. Should the city council fail to present those orders at this time, this court will reconvene on that matter no later than April the 11th, 2022 for a hearing to show cause why the city council should not be held in contempt for failure to comply with this court's order. Is there anything, this order will be reduced to writing. Is there anything further, Ms. Perkins?
Yes, ma'am. One moment, please. One thing, the minutes from February 10th, 2022 through March 24th, 2022, they have not been presented to the mayor.
In this order, whatever is required to have them finalized will be sufficient. It's my understanding they have been presented to the city council, although they are awaiting his signature. But the other orders have not been authorized and adopted by the city council at this time. So these minutes may be in various stages, but whatever stage it is necessary to satisfy the requirements of the statute that they be approved and signed should be complied with no later than April 4th. Anything further?
Yes, Your Honor, could be a very detailed order. We've got a situation where the mayor had one roll of the minutes up through February of this year, then that's changed. Would the court entertain the council looking at a draft prepared by your law clerk to comment on that order so that everybody?
I would try to write it as broadly as possible because I do not have, nor have I been presented through argument on the nuances of what you all need to do to make sure the order will stay